and I'm really excited today because we haven't had you on, Jared, to talk to our real estate community, though you have been talking to the real estate agents that you do. You are the #1 conveyancing real estate firm in the country. The volume that you do is extraordinary. You've turned that business into a McDonald's of conveyancing, I think.
Thanks, Tom. No, yeah, we're doing okay. Yeah, it's doing pretty well.
I would say if I'd studied law and come out a lawyer, I would have done exactly what you would have, done. I would have set up a firm that I would have specialized on just one thing, so I wouldn't get distracted, and I would make sure that I was able to work with one sector. Obviously, real estate is the right sector to be working in conveyancing, and you've done that. And I thought you would be the best person today to talk about 7 things that agents need to know about contracts. I want to preface right from the outset, the contents of this webinar that Jared's going to deliver from Dott and Crossitt is relevant to New South Wales, Victoria, and Queensland predominantly. Can I confirm that?
That's correct. Yeah. In fact, all the states and territories, there's some general principles on contracts we're going to touch on.
Okay. So this is important, and I'll tell you why. Because I'll do 10, 11, in spring, 12, 14 auctions on a Saturday. And I'll often, just before an auction starts, I'll have a real estate agent come up to me, or sometimes when the auction's finished, and they'll ask me questions. Oh, mate, can I cross this out? Can I put 5% there? Can I do this? Like, if they're only going to give me this, what are they liable for? So there's a lot of stuff that I think agents, and often I'm unclear as well, Jared. I'm unclear. Often I feel like I've got to pick up the phone and ring up, a lawyer on a mobile phone, because you need mobiles on the weekends. And that's the other thing I've heard about you. You do very well. You will take calls on Saturdays, on auction days, correct?
I do that. My wife hates it, but I do it. Yeah.
Yeah. So I want to go through it, because the real estate industry seems to attract a lot of people that come in. They're told, pick up the phone, hustle, get appointments, get listings, get sales. And then what you notice is that they're good on the sales side, but underneath the bonnet, often they're actually unsure of even things like reading contracts, or, finding where the sewer line runs in a contract, So let's kick it off. We're going to go through 7 things. We're going to try and get this done in 20 minutes. Number 1, what do you think is something that they should know? We've got a list that we're going to work through, but what's the first one?
Well, the first one I'm getting a little bit now, more so a couple of months ago when the market was looking dicier. But I had the question that was asked by both buyers and also the agents. If I default as a buyer, what am I liable for? Am I just liable for the 5% deposit I put down? In fact, sometimes we get buyers asserting that, saying, oh, look, I'm not going to complete. I'm just going to lose the 5%. I mean, the answer, you've probably already guessed, is you're not just liable for the 5% as the buyer. You're probably liable automatically as a liquidated debt. So it's a straightforward, simple debt for an additional 5% if they've put one of those fancy clauses in there. And even that brings you to 10%, right? And then if the vendor resells the property at a loss in the market, and if that loss exceeds 10%, well, the buyer will be liable for that as well. So I always say to my buyers who are approaching financial difficulties, don't just walk away, because the losses that you may suffer are unquantifiable. We don't know what they could be. They could be 5% if we're lucky, but they could be a lot more. So always try and negotiate some kind of firm settlement or resolution or an extension.
Okay, so point number 1, even if there's an agreement by the vendor to accept a 5% deposit, if you don't settle and don't fulfill, don't go to settlement and you pull out, you're also liable for a further 5%.
So you can be liable for a further 5%. I use the word as a liquidated debt. And that just means automatic. You don't need to put on an affidavit and establish that you've incurred these losses. You are owed an additional 5% by way of what we call these structured deposit clauses. And it's as simple as that. You say you've defaulted. I'm taking the 5% now from the trust account. You owe me another 5.
Okay.
So that,
Yeah. So
those clauses.
Sorry, Jerry, we've gone through 2 points then. Firstly, we've talked about, and they're really, I suppose they're 2 separate ones. One of them is the 5%. What you're saying is you could be liable depending if the clause is in the contract?
Yeah, and those clauses, I'll be honest, they're more common in New South Wales. I don't see them as much in my Queensland and Victoria practices, but you'll often have these clauses in New South Wales that says, even though we're going to accept a slightly small deposit, say around 5%, you are liable for the full 10 if you default.
Do you put those in your contracts?
I always put those in my contracts.
Okay. So the other one that we started off with was defaulting. And if you default, you tell your clients, don't just walk away, because what is a headache could get a hell of a lot worse.
Yeah, and we have no idea how bad it could get. It's unquantifiable. The vendor the market could absolutely just crap itself as soon as you default, and the vendor may lose 20, 30% vis-a-vis the contract price you agreed to. So it could get really, really bad.
Okay. So in essence, what you're saying to me is someone buys something for $1 million, they're liable for the $100,000. They don't go ahead. That property gets resold 4 months later for $900,000. So they're also liable for another $100,000.
No. In that mathematical case you just mentioned, that's it, because they've only lost.
Oh, sorry, you're right.
Yeah. So
let's assume it sells for $800,000.
Correct. And now in that case, they're liable for another $100,000.
Okay. Can I ask if the property, and this has happened in Byron Bay the other week, and I got asked the question, and I wasn't sure of the answer. The buyer defaulted. The property went back on the market. And surprisingly, in this market, it actually ended up selling for $300,000 more.
Yep.
So the vendor's happy.
Yep.
Can I ask you, does the original buyer, what's their position in this?
So the deposit is the deposit is the deposit. It doesn't matter that the vendor may have made money on the resale. You still lose the deposit.
Wow.
You can't ask for a refund. That's got nothing to do with it. So you almost look at them as 2 categories of things. First, you lose a deposit, and that's irrespective. It's a solemn, sacred rule of commerce going back hundreds of years. That's the first thing. Then you look at the second thing is, what has he additionally lost, if anything? And if it's more than the 10% deposit, guess what? You've got to pay that too.
Well, this buyer must be sitting back there thinking, I've lost my 10% deposit. And if I'd actually been the person that had just resold it, I would have got a $300,000 increase, because they get none of the benefit of that either.
See, he should have done everything. He should have hocked himself to the eyeballs and finance. And that's what I always tell my clients: you're better off settling and managing it from there than just walking away. Okay,
let's go on to the third thing that real estate agents need to know about contracts.
Well, it's coming towards the end of the year. So what you're going to start seeing now is land tax adjustments. They're going to be more and more negotiated. And I do get even the top agents in New South Wales, they'll often say to me, can you just remind me how this works again? And why is it that this mum and dad who are going to be owner occupiers, why are they being asked to pay land tax? So the answer is, and land tax adjustments are a concept across all states and territories. The concept is this, is that commercial or investor vendors, they pay land tax. Land tax is assessed at the stroke of midnight every year on the 1st of January, and you have to prepay your entire year's land tax. Now, the OSR, in their wisdom, they do not give you a refund if you sell your property, for example, halfway through the year. They say, no, you sort that out with your buyer. We just want our money, right? So the whole market, it kind of makes sense. The whole market would grind to a halt, at least as far as commercial property and investors are concerned, because they would never sell the property after they've just paid their land tax. They would wait right towards the end of the year. So that's where the concepts come into place, is that there's an adjustment. So if I'm an investor, I've paid $10,000 land tax on the 1st of January, and I sell my property on the 30th of June, then I'm going to ask for my buyer to make me good $5,000. So a 50% adjustment. Now, I'll ask that in the first instance, irrespective of whether he's an investor himself or whether he's a mum and dad who never pay land tax. They're two different scenarios, though. The investor is probably going to say, yeah, whatever, I pay land tax. I got my head around that. The mum and dad, they're probably going to panic. They're going to go, well, hang on a minute. We don't pay land tax. And it takes an agent to really settle them down and say, no, this is a one-off payment that the vendor is asking you to pay for. So that's the first thing I'd probably recommend that vendors do, is just calm everyone down. You're not going to pay land tax going forward. It's a one-off adjustment. The second thing is you should probably do is work out exactly what the figure is, because a lot of people get really emotional. Oh, shit, I have to pay land tax. But when you work it out, particularly if it's towards the end of the year, the amount is actually quite small. So yeah, that's a land tax adjustment. Look, it's sort of a commercial point for discussion. I kind of think it's neater if you're advising your vendors. I kind of think it's neater and cleaner just to say, look, just build it into your price rather than trying to confuse your buyers and getting them more emotional. Just build in whatever you think the property owes you. That's your price you're going to accept. But if you have a vendor
and do that and not ask the buyer to be paying
I think that's way better. It's way cleaner.
So Jared, let me give you a case study. 4 weeks ago, property in the southwest of Sydney. I'm about to start an auction, and the real estate agent comes up to me and he says, Tom, mate, 2 of the buyers, and there was only 2 buyers, right? He goes, 2 registered, 2 of the buyers feel uncomfortable about this clause that's there. And I said, like, while we having a chat like 30 seconds before the auction about them pulling out. Anyway, thankfully, well, it ended up being not so good. Thankfully, but the vendor goes, oh, my lawyer's a bit of a family friend. I've got their mobile. So I ring up the vendor's lawyer. Now, this vendor's lawyer was not in a good mood. I don't know. They had a late night on Friday night. It was a 9:30 auction. Oh, what do you want? Oh, I'll put you on to the auctioneer. I said, no, contract is as is. Contract is as is. I said, okay. I said, well, I'm letting you know, so you're aware, there's 2 registered buyers. Both people have asked for it. Basically, you're saying no. Well, there's a possibility we're going to get no bids. Anyway, the long and short of it, I hand the phone over back to the vendor. The vendor then speaks to the solicitor, and it ends up being what you just said. Like, it's a $3,000, $2,000. It's a $2,000 or $3,000 thing.
Exactly.
So I turn around and the vendor goes to me, Tom, it's a $2 or $3 grand thing. I said, yeah, we're trying to get $1.3 million a year, and we're worried about 2 or 3 grand. I said, we should get that in one bid. Anyway, it's sold way over reserve, but thankfully, sometimes even solicitors, they don't get the commercial aspect of it. They get hung up and dry. It's my contract. I've done it, blah.
Often they don't, Tom. And that's why I think the good agents, they will probably try and vet the contract before it goes to market. Not try and tell the solicitors what they should draft, but just have a bit of a think about it. Well, do we need this land tax adjustment? Because I know from experience, we are going to get pushback. And if the advice from the solicitor is, oh, yes, this guy's got a massive land tax bill and, we need to manage it and all that kind of thing, okay, that's fine. But I think the vast majority of times, if it's an owner occupied, or even if it's an investor, it's just cleaner if it's a resi property, just to keep it out.
So I bought it. It's funny we talk about it because I just realized it happened to me. I was the purchaser and it was a negotiation, and we were the same, My partner turned around and said, oh, no, the lawyer's come back with this and this. And it ended up being a $3,000 or $4,000. It was a $3,000 or $4,000. It never seems to be a lot of money for some reason, Jared. It's always like, it seems to be under 10 grand most of the time.
That would be the average land tax bill on the average property in Sydney.
So what happens is, it helped in my negotiation, because I turned around and I said to the agent in Byron, I said, listen, I'll go, I'm not going, this is my last and final figure. And I agree that I will do the tax, no problems.
Yep.
He goes over and speaks to the vendor. Look, I've got good and bad news. He's not coming up the extra 50, but he's agreed to take over the tax assessment, right? And the vendor goes, oh, well, we've met halfway. It wasn't really halfway.
Not halfway at all.
Right. Right. But you know what it's like in a negotiation, people feel like they've had a win. You know what I mean? That's what they want to feel like. Let's move on to the next one. And this one's one of my favorites because I'm going to learn from this one. It's always, oh, Tommy, you're at the auction, mate, the contract here, he hasn't got his company seal, he hasn't got that, this and that. It always seems like chaos, right? How do you sign a contract with a company as a purchaser?
Okay, so New South Wales, Queensland, Victoria, SA, Tasmania, all the same. It's corporations law. You sign for a company with any two directors' signatures, or the director and the company secretary. And if it's a one director company, then just that director. So if you have a 5-director company, you don't need all 5 directors. You just need any 2, or the director and the company secretary. And then if you have a 2-director company, then you need those 2 directors. So what often happens is you get the mum and dad sort of property shelf company where you've got husband and wife on as directors and only the husband signs. Now that is an invalid contract, and we've had that quite a lot. The way that you'd sort of overcome that, Tom, before you ask is, particularly if it's leading up to an auction, is when you register as a bidder, if someone's put down a company name, you ask them to accompany it with a ASIC search showing who the directors are. Shareholders are irrelevant. It's the directors that you need to know.
Okay. And can I confirm this thing, the old days, they bring their stamp.
Yep.
Is that necessary?
Well, it's not necessary. It does still exist. It still is a valid way to execute on behalf of a company. It's actually mentioned in the Corporations Act. I've been doing conveyancing since 2012. I've seen one contract executed that way. So, yeah. So it's probably easier just to do directors.
And can I just confirm, you write, as if they're the purchaser, you write the purchaser being the company. You have 2 of those people that you've indicated they've got to be.
Yep.
If there is one that attends the auction and the other's not there, what happens?
Well, they can't sign. They can't sign. That's a disaster.
Okay. Can the person that is absent have provided a letter that says, if we are successful, I give permission to such and such to sign on my behalf?
Yeah, you can always do that. But the way you probably naturally do that with a company is you probably get a corporate power of attorney. So you'd sort of say, irrespective of, and you'd have the 2 directors sign the power of attorney that gives the power to the one director to sign. But you need to have that power of attorney.
You might need to research what I'm about to ask you. So I'm not going to put you on the spot and say, why don't you know? But
that's all right. Test me.
So there's one there, property gets sold under the hammer.
Yeah.
The agent goes to sign the contract, realizes the other person is not present. Can they say the auctioneer sign on behalf of the other party?
Oh, definitely. Yeah, definitely. That's a different.
No letter needed. No, nothing.
Yeah, that's a principle of common law. Yeah.
Okay.
Yeah. So that's actually a good foot. So providing that they've been, so that with that case, that's a really useful tool. And I find a lot of auctioneers are a little bit reluctant to do it. An auctioneer, as you would know, Tom, under common law, they can sign for both vendor and purchaser if they're not there. A lot of auctioneers don't want to do it. And I kind of see why, but they probably should. That would take a lot of the guesswork out of when it comes to companies and the like. The only thing is there, it would still go back to the registration. If you don't have 2 directors who have filled out the registration, then the company itself hasn't validly been a participant in the auction. So provided you had that correct, then the auctioneer can sign.
Okay. Beautiful. So there is a bit. Look, I used to have apprehension, and I don't, because the bottom line is it's permissible by law, and it's a practical way to actually, end up executing a contract. Jared, for your own info, I had one. The buyer. It wasn't two parties. It was one party. It wasn't a company. The buyer buys a property under the hammer, won't sign the contract. I then say to them, I'm going to sign the contract on your behalf, and I'm letting you know that you've got to buy it, and it's over to the lawyers. He said to me, if you sign that contract on my behalf, something along the lines, you can say goodbye to the planet. And I said, all right. I said, okay. And he walked away. And when he walked away, I did sign it. I'm still alive.
Yeah.
Yeah, but you can. Like, if you've got a situation where a buyer's not signed the contract, you have to. So it's not a question of can you, it's you have to.
You have to. I think you've got a duty of care to your vendor. Do you know why the auctioneer can sign?
No.
Okay, it goes back to, have you ever heard the people say that a dealing in land has to be in writing? It's called the statute of frauds. So I can't verbally sell your property. That's a pretty well-known principle. It has everything, a dealing in land, a lease, sale of property, some of that, it has to be in writing. It's called the statute of frauds. It goes back hundreds and hundreds of years. So if you've got the statute of frauds,
to some other contract law, which you can have a verbal, isn't it?
Honestly, there's very, very few exceptions. One of the key sort of principles in property law, the statute of frauds, is that you cannot have a dealing in land unless it is in writing. Okay, so how do auctions work? Because that is the opposite of a dealing in writing. People are not writing it. So that the way that the courts, and this is I don't remember the name of the case, but it's hundreds of years old. That's how the courts managed to reconcile this legal principle with auctions. They said, well, auctions are valid because we will give the power and, in fact, the responsibility to the auctioneer to sign the contract immediately afterwards. So that's what sort of marries that up. So it's not a vague technicality. It's actually one of the important sort of ways that auctions actually work.
Okay, very useful to know that. So Jared, let's move on to the next thing that real estate agents should know about contracts. By the way, everyone, this is a webinar and it's a Q&A with Jared, Zach from Dott and Crossitt. Probably, do you actually think you do more conveyancing than other? I mean, I know I said it at the start, but I think that's probably a fact, isn't it? That's
New South Wales, we got the figures recently from PEXA, which are our online settlement platform. So we are number one in New South Wales. We've got a bit to go in in Victoria and Queensland, but we're up there as well. So
okay. Number 5, why, and this is a question, why do we need to guarantee if the purchaser is a company? Why do we need to guarantee if the purchaser is a company? You sort of half covered a bit there.
Yeah. So why do we need? So when you're executing with a company, you'll often sign at the front page, and then you'll hear the solicitor say, "Make sure you get the directors to guarantee." And it's about halfway through the contract. It's after the special conditions. It's normally a 1-page document, and the directors sign again as personal guarantors. So it's really important to get that, and not very often it's not, you don't get it, you miss it because it's halfway through the contract. And the reason is, I mean, you can probably work it out, but the vast majority of companies, PTY LTDs that are used to buy properties, they don't hold any assets. They're just shelf companies that have been set up on the Friday before. Now, if you sign a contract and you put down that 5% deposit as a company, and if you default, remember the first question we said, I said, what happens if a buyer defaults? Does he just lose a 5% or is he liable for more? Well, from a legal perspective, he's liable for more. From a practical perspective, if it's a PTY LTD company, doesn't hold any assets, well, that's the end of the story. You're not going to get any more money. The people are just going to let it go insolvent. So that you really don't have much skin in the game unless you've got a personal guarantee. So it is really important, particularly if you're only getting a 5% deposit.
So we're going to answer a question that Anthony's asked in a moment. I know I said to you 3 o'clock finish. Have you got 10 or 15 more minutes?
Yes, absolutely, of course.
Okay. So Jared, because I want to ask you before we move on to that question that's come in from Anthony, I want to ask you, what if you, in that case of the company, is that clause in every, is there a section for directors' guarantees in every contract?
It's a great question. It's not, Tom, because vendor solicitors are not always, always good, to be honest, and a lot of them will miss it out. I'd say they're probably in 80%. I know that there's at least, we picked this up on a teaching session I had with Stephen Bertram's team, if he's watching out there, where he sort of said, well, hang on a minute, aren't we running a risk if we're not guaranteed to have guarantees in every contract? And they said, yes, it is. So now when they send out the request for contract to the vendor solicitor, they always say in bold type, please ensure your special conditions contain a guarantee. Because to answer your question, Tom, no, they don't. I'd say 70 or 80% do.
Yeah, I look, I'm aware of a transaction where it was exactly that. The company was set up on the Thursday, the auction was on a Saturday, and the actual purchaser basically turned around and said, listen, if I were you, I'd be going off and trying to sell it to someone else because you can sue us. You're getting nothing, right? And I think the agent actually followed their advice and went to try to do a deal with the underbidder. So,
well, he has to. That's the smart thing to do there, because if there's no guarantee, all you've got is 5%, which cannot. It's not a lot, really, particularly when the market's going. When you're reading when you're in a sort of a downward sliding market, as we were 6 months ago, it's not a lot.
Look at these questions that have come in. I'm just going to read them out because they might be relevant to what we've just been speaking about. Anthony Funovic, back to question in relation to directors. Can one party sign and or nominee? Put down and or nominee.
So I think I interpret this question as more talking about the and or nominees clause. Now that is a state-based thing. So I won't propose to give an answer at the moment because it does very much depend if you're New South Wales, Queensland, or Victoria. Why does it depend on the state? Because it goes to whether or not the Office of State Revenue will determine as to whether or not that is a sub-sale or effectively two transactions that they were duty. As a matter of contract law, you can absolutely write and or nominees. That's fine in every state and territory. You can do that. The question is, will the Office of State Revenue stamp you twice? General answer, in most of the states and territories, yes.
Okay, that's an interesting one because I still think it's hanging around because often you get a buyer, they're signing the contract, Jared, right? David and look, I don't know. I might put it in my I might put it in my son's name too. I'll just put or nominee and I'll let you know. So there was always this assumption that if it was the wife or the children,
that's correct.
It would be. Can you elaborate on that?
Oh, well, I can. Yeah. So off the top of my tongue, the section 18(3) of the New South Wales Duties Act, and there's equivalent in other states, says that if you put and or nominees, and it's a husband, wife, boyfriend, girlfriend, son, daughter, I think brother, sister, we won't stamp you twice. But the corollary is anyone outside that sort of family nexus, well, you are going to get stamped twice.
Okay, so I think if you're an agent, the right thing to do is, if you're doing that, is that you actually say what you've just said, and that is, I can put whatever you want on here.
100%.
I'm letting you know that the Office of State Revenue are going to decide on whether you pay stamp duty once or twice, as long as you're aware of it. That other last bit that you spoke about, the immediate relative, is that also a state-based thing?
Yeah, it's all state-based, but most of the states seem to converge on that concept. So I'm fairly sure all the states have that concept of, close family you can transfer. But look, if in doubt, and if you want to move it to a business partner or you want to move it to a new company you set up on Monday, it's a pretty easy thing to fix up. I mean, particularly me, I've got no problems at all. If I'm acting for a vendor and a buyer solicitor comes to me on Monday and says, look, we stuffed up, we bought it in this name, but we should have put it in this family trust. No issue at all. We can fix that up. You just have to cover my legal fees, which I can assure you are pretty modest to do it. There's no issue. We all want to make the deal happen. We don't want to kill it for a technicality. So,
Okay. Shane Fox has just asked if the contract is invalid. I think it's what he's saying is the contract invalid because only one director signs, and can it also make and sign? Can the vendor also make the contract void?
does he mean if the vendor's a director? Is the vendor's a company?
The contract
that can happen too.
Only one director. So let's make the assumption that, well, we can look at both scenarios. So what happens is the vendor is a company and only one of the vendors signs. Is that an invalid contract?
Well, the purchaser could pull out. Yes.
And then the other way around, if it's a purchase,
Yep.
The vendor can pull out.
Yeah, exactly right.
Can the buyer pull out?
Well, they can as well. Yeah, it hasn't been an effective exchange. So it's a
damn
nightmare.
It's damn important to actually know who the directors are of the company.
Oh, honestly, I don't want to scare you guys, but if you see a company, you should be thinking alarm bells. It's just, yeah.
Right.
I've had one the other day where we were selling a property, and the company all existed. We thought it existed. Mum and dad were on there. They owned the property for years and years and years. We did a ASIC search just before we went to auction, and we found out the company had been deregistered because mum and dad hadn't been paying the ASIC fees. So under the corporations law, a deregistered company, all of the assets of the company vest in ASIC when it gets deregistered. So we had to cancel the auction. It wasn't the end of the world. We have to just pay the fees back and ASIC give you your money, give you your assets back. But honestly, it's definitely worth stopping and thinking when you see a company either as buyer or seller.
Okay, beautiful. Next question, and I know we've still got, I think, 2 more points to go, but I'll get through these questions. Do the guarantors require independent legal advice before signing personal guarantees, or is this waived under these circumstances?
Yeah, good question. And I know where it's coming from. It's coming from, you always hear about banks, CBA, NAB, all those big banks. They always require guarantors on mortgages to get independent legal advice. So is it the same for a contract? The answer is no. With the guarantees with banks, it's really a Royal Commission type thing. There was a lot of scrutiny on, particularly elderly family who were asked to go guarantor under loans, and the whole transaction wasn't explained to them properly. So banks have taken that approach. Okay, any loan that requires a third-party guarantee needs independent legal advice. That doesn't follow across to contracts. There's no independent legal advice required, particularly if it's a director.
Perfect. Jared, deposit releases. Deposit releases. This is another thing. Oh, mate, they want to release the deposit. Sometimes can help in negotiation. But is there risks with releasing the deposit?
Yeah, there's risk, but it's a fairly small one. Let me just tell you the quick story because I think it best illustrates the point. So I was acting for a buyer up in the Blue Mountains. They found this dream property they wanted in the Blue Mountains from this pretty funny old esoteric vendor. They agreed on price, albeit the vendor wanted a long settlement date, and he was adamant that he have a release of deposit, and he needed 200 grand release because he wanted to buy something down in the Shire. Now, very reluctantly, and I still think back at this, we agreed to it. So we agreed to this long settlement date. 5 months down the track, and we released the deposit. Now, come a week before the settlement date, we go onto the PEXA dashboard to see how settlement's looking, and we see not one mortgagee on the vendor's title, not 2, but we see 3. And we say, well, shit, what's happened between exchange and settlement? And we start to sort of write messages on PEXA. Are you guys looking okay to settle? What's going on? And we go to the settlement date. It gets delayed again. We go, what's going on here? Oh, we're having a few problems with our banks. Yeah, no joke. And anyway, it goes on for about 30 days. And then we eventually say, well, you've obviously got some financial matter that you can't release your security. Your banks aren't happy. So we're going to terminate, and we want to go our separate way. And we want our money back. And they said, well, look, about that, remember you released the deposit to us? Yeah, we went and bought that place down in the Shire. Yeah. yeah, that happened a few months ago, and and yes, we are in financial difficulty, and yes, we got our deposit taken. So bad luck.
Oh, wow.
So my clients lost money in that situation. Terrible situation. I guess just to reflect on that, Tom, that's a pretty unlikely case. It's a pretty rare case, but there are a few things that should have stuck out, and they now stick out in my memory when I'm looking at release of deposits. The longer settlement dates, right? The longer you give something to go wrong, the more likely it will go wrong. The other thing is financial distress. Now, when we looked at his title, when we first reviewed the contract, there was only one mortgage on there, but it was to a subprime lender, like a sort of a no-name bank. That's normally a little bit of an indicator that there's financial distress. And if you see 2 or 3 mortgages on there, guaranteed, you should not be releasing the deposit if that's the case. So if you are going to agree to them, a little old lady who's unencumbered property, you probably think, well, that's okay. But some sort of developer type personality that's got a lot of debt and looks a bit stressed out, I think that's probably high risk.
Jared, while we're on that point, what advice can you give to the real estate agents watching this, both on Facebook Live here or watching it on replay? Because we are going to send this out to our database for Queensland, Melbourne, and Queensland, Victoria, New South Wales. What advice do you give them about how to work out the mortgage situation in a contract? I mean, you can open up, I know, the New South Wales contracts and see it at a specific section. Can you just let us know, is it in the contracts?
Yeah, so in New South Wales, as you know, Tom, it's about halfway through. In Queensland, it's at the back of the contract, and sometimes it's not there. So you sometimes you won't, if you're a buyer, or in Queensland, the vendors are putting the contracts together. Queensland agents, if you're out there, I would strongly recommend when you do that to add the title search. It's only $10 extra or whatever it is. Adds a lot of clarity to the situation, and it may even help you because you might see on there or a caveat on there or a covenant or a right of way, and that will help you with your discussions with buyers. With Victoria, it's in the disclosure statement, and also it's in the disclosure statement in South Australia as well, without going to the rest of them.
Okay. Last one, number 7. What happens if a vendor leaves items in the house? Can the purchaser delay settlement or pull out? So you go there to your final inspection before settlement, and you see they haven't left behind, an antique $50,000 dining table, but there's just, a bit of rubbish all over the place. And you think to yourself, like, what's going to happen to this? Can you turn around and say, I'm not settling today?
Yeah, so it's a good question, and it's all around, again, it's a universal or an Australian-wide concept of vacant possession and what vacant possession means. So contrasted with a clause which says as is where. So sometimes you see that in the old squatters' houses and the hoarders' houses. You might see a clause in there that says you just take it as it is, but the vast majority of properties are vacant possession. So vacant possession, firstly, what does it not mean? It does not mean clean and tidy. Okay, so dust, dirt, even little small bits of rubbish, that does not mean you're not being given vacant possession. And you often get buyers, cry and kick up a stink because they don't have a clean house. Well, you're not entitled to one, is the harsh truth. Having said that, if there is a big item in the property, and it's a question as to what actually is so big that it would invalidate vacant possession. I'm thinking something like a pool table, something like beds and that kind of thing that weren't meant to be in there. The principle that the case law has laid down has said the item left behind has to be so severe to be an impediment to your being able to enjoy the property in its natural use. So a box, a few bottles of wine, that's probably not going to be the case. But the bigger the items, the more likely it's going to be a failure to convey vacant possession. If you have not conveyed vacant possession at title, well, yeah, it's a breach of contract. You can't pull out straight away. You have to issue a notice and say you haven't complied with your vacant possession covenant. But if after 14 days, they still haven't provided that vacant possession, got rid of that large item, whatever it is, then yeah, the buyer can pull out.
Okay. Jared, fantastic. Susan, if you're in the background, I'd love you to put Jared's details both on Facebook and in the chat box, if you don't mind. And I just want to confirm, you have been listening for the last 45 minutes. The great man, Jared, Zach from Dott and Crossitt, representing real estate agents with their legal matters, Queensland, New South Wales, Gold Coast as well.
Absolutely. We've got a Gold Coast office up there. Actually met your friend Jane up on the weekend. I had dinner with her, Jane Dugan from LJ Hooker. She said to say hi.
Yes. So you visit the Gold Coast?
Yes, yeah. I'm up there pretty frequently. Yeah.
Now, Jared, I don't know what your movements are like, but I've got a real estate gym plus event on September the 8th. So just picture Friday. It's pretty much 2 Fridays from this Friday. And John McGrath joins me where we have these high performing agents we mentor. I would love, it's somewhere in the inner west. I would love if you're around to come and do a half-hour presentation. I can talk you off there. That's Friday, September the 8th. That's the first half of the days. So when you hang up here, if you can just go to your diary and just sort of block off, say, like 10:30 to 12 inner west, and we'll let you know. But I want to thank you so much. Absolutely outstanding. Dott and Crossitt. This has been Jared talking to us about the 7 things agents need to know about contracts. And I've got to tell you, you're going to need to, because the stock is beginning to fly in. Surely at your end, you must be preparing a lot of contracts at the moment.
Heaps. Yeah, the most we've ever done the last couple of months. Yeah.
Happy days. All right. Thanks a lot.
Thanks,
Jared.
guys.
Thank you so much.